Good morning. So far, Guardianship and Wards Act is concerned. You must understand that the Guardianship and Wards Act 1890 is applicable generally for appointment of guardians. The Hindu Maintenance Minority and Guardianship Act may be read with this Guardians and Wards Act because Guardians and Wards Act deals with enabling provisions to follow Guardians and Wards Hindu Minority and Guardianship Act. To understand these acts, AAR 2022 Calcutta 344, AAR 2022 Calcutta 344, Momonai Paul versus Samir Paul. In this case, the judge division bench deeply discussed about what will be the provisions for appointment of guardians. For appointment of guardians, if natural guardians are not available, so who all are natural guardian should be understood if he is a Hindu under Hindu Minority and Guardianship Act, under Shariat or Sunni law text, if the child is belonging to Muslim community, and the Indian Christian Act will speaks about the custody of the natural guardian of the children. Here they say Guardians and Wards Act was first statute that primarily enacted to consolidate various acts then in force, keeping in view the personal of diverse communities in India. Section 7 gives power to the court. If it is satisfied it is for the welfare of the minor that an order should be made. Then Section 17 enjoins upon the court to have due regard to the personal of the minor and especially take note of circumstances which points towards the welfare of the minor. Then they say Hindu Minority and Guardianship Act 1950 was enacted as a law complementary to the Guardians and Wards Act. So, Section 6 of the said Act says who all are the natural guardians of children. Section 6 says in respect of minor property, unmarried girl and the father, unmarried girl and case of boy, father is the natural guardian. However, mother will have a custody of the child up to 5 years. Section 13 says about the declaration of guardian for minor by the court for the welfare of the minor by considering the paramount consideration. So many Supreme Court judgments were discussed in this judgment. Today I restrict. Here is the case where I referred this Momonai Paul versus Samir Paul. Despite the order to produce the child, the mother disobeyed the order. But however, there was no cross-examination opportunity was given to mother. Therefore, the division bench of the Calcutta High Court says that may not be corrected. Therefore, they allowed her defense and remanded back. However, they say the child custody should be granted to father, and the mother granted visitation right during the pendency of the remanded back matter. And further, since the court initiated perjury offences proceedings against the mother, they say since there was a total disobedience, the mother being a constable, police service, who ought to obey the law, deliberately since not obeyed, they have directed the court to take appropriate steps under 340 CRPC for offence of perjury. All these cases were discussed here. 340 CRPC relating to offence of perjury we can deal with in some other case. Best wishes.